So why should California publish its bill drafting manual? According to the National Conference of State Legislatures, the NCSL, about half of the states publish their manual used by the state's legislative drafting attorneys. California and its Office of Legislative Counsel is one of those states that does not. Why do I think our state should publish its bill drafting manual? I believe it would enhance the ability of the state's judiciary to better interpret statutes. When first reviewing a statute, judges and justices on the appeals courts rely upon the plain meaning or the ordinary meaning of the words in the statute. However, when that statute is ambiguous, then our state courts will try to ascertain the intent of the legislature. And in my mind, one helpful document to assist the judicial branch in interpreting the statute could be the drafting manual used by the attorneys in the OLC. Why? Well, this manual sets forth the rules that the California legislature's drafting attorneys follow when they draft bills and amendments that ultimately become statutes contained in California's 29 codes. Knowing how and why statutes are drafted in a certain manner, in my opinion, can benefit the judge or justices when they're trying to understand and interpret those statutes crafted by the legislature's attorneys. Now, while allowing judges access to the OLC drafting manual is not going to answer all the questions by any means, there are undoubtedly valuable insights that can be gleaned by an examination of the manual's directives and the basis for those directives. Now, while judges certainly desire to rely primarily on the textual language of a statute, having insights into drafting practices will give the judicial branch a better understanding of the legislative perspective. I've often said I think legislators and their staff should get some firsthand experience in statutory interpretation training from the judicial branch. And in a similar vein, I think judges should get firsthand experience in the legislative process and legislative drafting training from the legislative branch. This would give both judges and legislators a better perspective on each other's roles. Now, while the courts don't have to follow a drafting manual when interpreting an ambiguous statute, just as they don't have to follow codified statutory construction principles, for example, being able to consult with this manual could come in handy and bring some helpful guidance and insights to the judiciary. More importantly, if the stated goal of interpreting an ambiguous statute is to try and ascertain the intent of the legislature, then the drafting manual could shed some light on that goal and assist judges and justices in their crucial endeavor. Again, this is because the legislature's drafting attorneys have a method of drafting, some of which is unique to California. Even the federal courts rely on the drafting manuals from the U.S. Congress. For example, the drafting manuals are used to understand the grammatical structure of complicated provisions in light of the drafting practices of the U.S. House and U.S. Senate Legislative Council. It was cited, for example, in the case United States versus O'Brien in 2010. So finally, the judicial branch could even suggest in their published decisions when appropriate changes are warranted in the drafting manual, or perhaps suggest an addition when the manual is silent. In other words, having access to this manual could actually help both branches of state government. California continues to be less of a common law state and more of a statutory state. And as such, I think it would assist the judicial branch in its interpretation of state statutes by having access to that drafting manual.